All right, good morning. This is the Colorado Energy and Carbon Management Commission General Wednesday meeting. It is August 9th and it's 9 a.m. Let's have a roll call.
Thank you, Mr. Chair. Commissioner Ackerman, Commissioner Cross,
Present.
Commissioner McGowan,
Here.
Commissioner Mesner,
Here.
Commissioner Oath, Commissioner Ray, Commissioner Robbins.
Here.
Mr. Chair, you have 4 out of 7 commissioners present.
Great. Good to see everybody. Welcome to our virtual meeting. Again, Colorado Energy and Carbon Management Commission Wednesday business agenda, Wednesday, August 9th. We start with commissioner comments. And if commissioners will bear with me, I've got some prepared comments. This involves something that we've seen quite a bit recently, stratigraphic wells, and I want to propose a solution for that. So recently we have seen several variance applications for stratigraphic wells. Stratigraphic wells are typically drilled to obtain scientific data to support specific project needs and can include obtaining a variety of subsurface data in order to better inform decisions related to the goals or requirements of the project. Emerging industries, that's us, you guys, ECMC, carbon sequestration, deep geothermal, etc., may utilize these types of wells more frequently as the resource may be less defined than existing development within industries such as oil and gas. The primary purpose of drilling stratigraphic wells is to collect scientific or engineering data in order to provide context for decision-making. These wells will play an important role in characterizing subsurface reservoirs for new and emerging uses, such as sequestration or geothermal energy development, and to meet the requirements of certain permitting processes. For a variety of reasons, including allowing projects to progress in a safe and timely manner, stratigraphic wells should be evaluated in the context of what they are and not what future plans for them may or may not be. The initial goal of these wells is not to produce or inject, but is to verify project viability and to inform the future direction of the project. Stratigraphic wells are part of the site characterization process and represent a decision point for the project. If the data collected does not meet the requirements of the specific project, the project may be abandoned. However, if the data from a stratigraphic well supports further investment, the well may be converted for use in the project as a producer, an injector, or a monitoring well, depending upon the specifics. Because these stratigraphic wells are not production wells, all considerations and regulations applicable to a specific resource development project, i.e. oil and gas development, geothermal, sequestration, etc., do not fit the intent of a stratigraphic well. Specific project consideration and regulation should and can be applied to a project that seeks to convert a stratigraphic well for a different application at a later time. Given the differences associated with stratigraphic wells, the Commission processed them recently through variance applications to our normal OGDP process. This has resulted in additional time and energy on the part of staff and the applicant, which at least I do not believe is reasonable or necessary given the differences of a stratigraphic well from a normal producing well and gas well. I have had a number of discussions with the director and permitting staff to identify a reasonable approach to the regulation and permitting of a stratigraphic well differently than a complete and active resource development project. Given these discussions and in agreement with the director, I wanted to propose to the commission and staff that ECMC adopt a standing order that stratigraphic wells be processed using the Form 2A only, and that it not require the 2B or 2C forms, and that they are allowed to be processed and approved administratively by the director unless there are issues associated with the proposed well that the director identifies deserve the review by the full ECMC commission. I also propose that when we get to a future cleanup rulemaking that we process this proposal formally into our rules. The OGDP permitting process is necessarily robust in order to ensure the safe and responsible development of oil and gas resources. For a stratigraphic project, however, where no oil or gas or other resources will be developed, the OGDP permitting process is somewhat superfluous since many of the rule-based requirements for oil and gas development should not apply to a stratigraphic well. As more operators seek to drill stratigraphic wells in order to assess the potential for geothermal, Class 6, or other emerging technologies, including those technologies that may result in a reduction of emissions or abatement to climate change. A more streamlined permitting approach should be developed until the ECMC is able to conduct a thoughtful rulemaking with stakeholder involvement. So that was my, I typed that up because it was a lot. But basically, I propose that we direct staff to create a standing order for stratigraphic wells, that they be administratively reviewed through the 2A process, that they be administratively approved by the director unless there are some contingencies or circumstances that deserve full review by us, and that at a future date when we get to cleanup rulemaking that we codify that process at this point. We've got a lot of interest in particular in geothermal stratigraphic wells at this point within the state, and this will allow us to create a process that is protective and reasonable and necessary to review stratigraphic wells while also not unduly burdening our staff and proposed stratigraphic well applicants from having to go through the full-blown variance process, which is the only process we have right now. Reviewed this with the AGs to feel that this is a comfortable approach for us at this point in time. It'll be a sort of a band-aid until we can get to that cleanup rulemaking. But that is something that I would propose that we direct the commission or direct our commission staff to review, come back to us with a proposed standing order that can assist those that are seeking scientific stratigraphic wells within the state for the interim. So that's a lot. Don't mean to hit everybody upside the head with a lot at 9:07 on a Wednesday morning, but it is something that we've had a lot of discussion between myself and staff about, and that would be something that I would propose. So if you want to think about it, great. If you want to thumbs up, at least as to the concept and the direction, then we can provide that thumbs up to staff, and nothing happens until they come back to us with a proposed standing order for our consideration. So there you have it. Other commissioners with thoughts? Commissioner McGowan.
Thank you, Mr. Chair. And I'm sorry, have we approved stratigraphic wells? This is a dumb question, but not via like a hearing where we've gotten a presentation.
No, they've actually come to us via hearing, via presentation, and then via the variance process. So through the variance process, they've asked that they be approved without having all of the formal legalities of the 2B and 2C. And all I'm trying to do is suggest that let's not codify it, but let's just create a process that is consistent with the variance process that we've used for the 2 or 3 that have come before us. I see that Ms. Larson has visualized herself. Do you want to add to that?
Thank you, Mr. Chair. It was just to confirm that we have heard 2 of these. It was in May and June of last year.
Okay, sorry.
And I think oh, go ahead, Commissioner.
So that being said, if we think this is something that's going to show growth, and I assume that drilling a stratigraphic well uses some of the same equipment that we need for drilling regular wells, there may be, I feel, emissions impacts, some sort of cumulative impacts that I, as a commissioner, would like us to be tracking. And so I don't know what that would look like. I don't know if we need something robust. If it's in a non-attainment area, do we need CDPHE consultation? I'm not opposed to this idea. I don't feel like I know enough, Commissioner Robbins, to make an informed decision about a thumbs up, and I apologize. I don't feel like I know enough to make a decision today.
I had brought up the idea that we sort of undo the variance process, because the variance is not really kind of the right administrative approach for this sort of thing. And I'm just trying to amplify on that comment that I made about a year ago when the first variance showed up. And there seemed to be some agreement amongst commissioners that that made sense. If we do kind of a thumbs up to staff this morning to sort of say, go evaluate this, I think the thumbs up could incorporate your points, Commissioner McGowan, so that as staff is thinking about how to create a process that they think about emissions and non-attainment and that sort of thing. All right, I'm seeing Commissioner McGowan nod in up and down fashion with a thumbs up with her comments attached. Any other comments, Commissioner Cross, Commissioner Messner? Commissioner Cross?
Thank you, Mr. Chair. I agree with Commissioner McGowan. I think that this is, I'm not necessarily opposed to this idea. I always like the idea of helping staff, especially with more administrative type information to help the efficiency process. I'd be interested in seeing the proposal that comes forward from it.
Okay, Ms. Larson, I think you are getting a tentative thumbs up with some apostrophes attached. So inform the director and Ms. Trask to move forward with development of an idea of a standing order around this, around the concepts that I talked about. And then let's bring that back to the commission in a few weeks, and we will cogitate around that and see if it makes some sense to do something here.
Certainly, thank you.
All right. And Director Murphy is out of the office this week. And so Ms. Larson is serving as acting director for the good of the cause, everybody to know. So really appreciate Ms. Larson stepping up and serving in that capacity. I know we're going to get an update from Commissioner McGowan, but I wanted to see if we did have one person sign up for public comment. That's Barbara Mills Bria. I do see that she's in the hearing. Why don't we go ahead and adjust our agenda so that we can hear from Ms. Mills Bria first. She's the only person that signed up, so we'd love to hear from her. I see that she's now been impaneled.
Yes.
Good morning.
Good morning. I have to get myself set up here just a bit and then I'll begin. Okay, are you guys ready for me to start?
Yeah, we're ready for you. Go
And
for it.
I assume I have about 3 minutes as usual.
Yeah, you have about 3 minutes. I'm not going to time you. You're the only person that signed up, and we'd love to hear from you. But
Oh,
if you could keep your
great.
comments within that general time frame, that would be awesome.
They pretty much are, but I won't have to race through and
Nope, no
Stumble.
racing.
okay, no racing. Okay, so as a taxpayer in Colorado, it is extremely concerning that the financial assurance rules so recently established are being thrown out the window for KP Kaufman. If KPK's proposal is actually approved, many operators will attempt in the same way to manipulate data to jockey themselves into the option with the lowest bond amount. ECMC Director Julie Murphy in her December 29th, 2022 Notice of Intent letter to the United States Department of the Interior's Office of the Secretary, Deb Haaland, applying for the $25 million first round formula grants established in Section 4601 of the Division of the Bipartisan Infrastructure Law for the purpose of orphan well site plugging, remediation, and restoration for determining, quote, the projected cost to plug or reclaim those orphan wells, reclaim adjacent land, and decommission or remove associated pipelines, facilities, and infrastructure, states explicitly on page 3 under projected plugging and reclamation costs. The basis for this estimate was, this is a quote, was derived by multiplying the remaining wells to plug on an orphan well site by $50,000 per well to plug abandoned flow lines and remove production equipment. Estimated environmental and reclamation costs of $25,000 per single well sites or $35,000 for multiple well sites were added to the plugging costs for the site, end quote. Director Murphy, in her $47 million application for the federal grant, represented to the federal government that $75,000 to $85,000 was the estimated cost to plug, abandon, and reclaim the orphan well site in the state of Colorado. So, sorry for the trash truck. So if Governor Polis's commission is now saying it's only going to cost $39,000 for KPK, the highest risk operator in Colorado, for orphaning their wells to plug and remediate, Then you misrepresented the actual cost to the Department of Interior and disregarded your own orphan well average cost of $92,710. So how can you justify bonding the highest risk operator in Colorado for less than the amount of money taken from the federal taxpayers? The citizens of Colorado are angry about this failure and are considering filing a complaint with the Department of Interior to recommend no further funding from the federal government for the purpose of plugging orphan wells in Colorado due to ECMC regulatory failure in this case. In considering the discrepancy in KPK's cost filings, and you should see DECONO's response to KPK's supplementation of Form 3, you should be made aware of Colorado Revised Statute 18-8-306, which states that, and this is a quote, attempting to influence any public servants by means of deceit with the intent thereby to alter or affect the public servant's decision or action concerning any matter which is to be considered or performed by that public servant or the agency or body to which the public servant is a member commits a Class 4 felony, end quote. You, the commission, are appointed by Governor Jared Polis. So you're the governor's commission. So your failure is the governor's failure. Your failure is potentially a tax of billions of dollars on the people of Colorado. So thank you very much for letting me make these comments. I really appreciate it.
Thank you, Ms. Mills-Bria, for being with us this morning and providing the comments. Deputy Director Larson, I would instruct that you ensure that these comments are included in docket 230400117. That is the KPK Financial Assurance Plan docket. And so we want to make sure that they are added to that docket so that the commissioners can deliberate with these comments in mind when they take up that docket. So thank you very much, Ms. Mills-Bria.
Okay, thank you. I'll make sure and submit them.
Oh, that'd be great. If you want to submit them in writing to that docket, that would be great. And Deputy Director Larson can assist you in that undertaking.
Okay, perfect. Thank you.
All right. Moving down our docket, I failed to ask if other commissioners had just general comments before we get to the cumulative impacts rulemaking. Any other general commissioner comments? Okay, seeing none, we will take up the next item on our agenda, which is the cumulative impacts rulemaking process. Commissioner McGowan, you are recognized.
Thank you, Mr. Chair. Just to remind folks that the commissioners were all assigned some various duties and activities over the next 12 to 18 months, and cumulative impacts rulemaking is under my little umbrella. And I've been thinking a lot about Commissioner Ackerman's work and how he kicked the commission off with our listening sessions. And I think that's a good place for us to jump from and figure out how we kind of move forward from there and combine the requirements that came out of House Bill 1294 and the governor's signing letter of that bill. And I feel that a process that has been successful for the commission in the past and that is being proposed today is to form an informational docket first, where folks can submit their thoughts about the cumulative impacts process, the requirements of 1294, changes to our processes or data or our CIDR database and how we collect data, anything additional that they might have that they want the commission to consider. I would urge folks as part of the informational docket to include how the commission would implement what they are suggesting. I think we had a lot of compelling comments during the listening session, but as this commissioner, some of those ideas were hard for me to wrap my hand around about how the commission would actually implement some of those ideas in our rules, for example. So starting off with an informational docket with written responses, which we do September 15th. Then an opportunity for folks, whether they submitted written comment or not, to be in front of the commission in mid-October, October 12th and 13th for an informational hearing, where they could present those written comments, or if they didn't submit written comments, they could still submit their comments or thoughts publicly with an opportunity for the commission to respond. An opportunity for our staff to also give a presentation based on what they hear from folks and kind of what they've observed and their experiences with our cumulative impacts process to give their ideas. And then that leading to the commissioners discussing what they've heard and requesting the drafting of a rule. And then that would trigger a formal rulemaking process where we would have draft rules for folks to respond to redline, submit party status, etc. So that's what I'm thinking. I'm hoping that that is an agreeable process forward with the other commissioners.
Great. That sounds awesome. Thanks for putting the attention to that. Want to thank Commissioner Ackerman for the great work kind of getting this thing teed off. In the interim, we did receive, was it 1294, Commissioner McGowan? I can't remember the House bill that identified direction for us on cumulative impacts. I think that really does a good job of sort of streamlining what it is we're supposed to do. Thrilled that you're able to take up and move forward with this. I assume that the comments you just made are going to find their way into some sort of written document that Deputy Director Larson can put on the website so folks can sort of find that. Is that right?
Yes, so pending a thumbs up from the commissioners, I know that Deputy Director Larson has been working on some language with me to post out there into the world for folks to start thinking about responding to.
Deputy Director Larson, is that accurate? You got that?
Yes, assuming the rest of the commission is supportive, we will be able to get that information out to the public and post it today with information about how
great.
their information.
Well, seeing that this is kind of a thumbs up sort of morning, do we have thumbs up for this concept, guys? Commissioner Messner?
Thank you, Mr. Chair. I am a thumbs up on this. I just wanted to commend Commissioner McGowan for continuing to move us down the path here and creating some structure to this. I am looking forward to starting this process, and the process that you put forward is a logical process and one that we've utilized in the past with success. And so I appreciate that and am supportive of the concept. So thank you.
Great. So I think we've got a thumbs up direction here. So that'll get posted to the website, and we'll look forward to folks engaging with us on this second round of working on the important topic of cumulative impacts. And for the record, we've been calling Ms. Larson Deputy Director. I just want to note for the record that she is now the Deputy Director for Policy and Administration at the Commission, and applaud her assent to that position and look forward to working with her in that capacity. And thanks also for sticking around and being our hearings manager for the interim, because you do a great job there. And I don't know if we would nearly be as seamless as otherwise, but I know we're going to have some other folks help us with that. So moving down our docket, exciting times. We now have docket 230400117. This is indeed a quick check-in on KPK's financial assurance plan, which is set for hearing next Wednesday, not today. So if we could elevate the relevant attorneys to the docket. I had some procedural matters that I wanted to raise with folks today to make sure that next week we're kind of seamless and moving forward with that.
And Mr. Chair, while we're doing that, would you like to take up consent agenda?
Oh. Yes, I would, although I do not see that on the agenda. So let's modify the agenda. Let's ensure that we've got a oh, here it is. Consent agenda was after KPK, but we can go ahead and take that up now. So we have 4 hearing officer recommendations under Rule 505. Are there any questions from commissioners on consent? Seeing no questions, is there a motion to approve consent?
So moved.
Second.
Moved and a second on consent agenda. All those in favor signify by saying aye. Aye.
Aye.
Any opposed? All right, look at that. We're knocking this agenda out like no tomorrow. Consent agenda is now approved. We are now looking for the attorneys that will help us with the KPK procedural matters. I see we've got Mr. Jacobs, we've got AG Boudreau. Is there anyone else that we were looking to see on this matter? Perhaps Mr. Lewis Prescott
Also, Mr. Matsura, Mr. Chair.
and Mr. Sura. Okay. Give us a sec as we find these guys. All right. Let's just do a quick roll call. Mr. Boudreau, if you want to introduce yourself and who you're representing.
Thank you, Mr. Chair. Assistant Attorney General Benjamin Boudreau. I represent ECMC staff.
Great. Mr. Jacobs.
Don Jacobs with Davis Graham and Stubbs for respondent operator KP Kaufman Company, Inc. With me today for KP Kaufman Company are my associates Nicole Rushovich and Cole Killian, and KPK's General Counsel, Mr. Ross Watsman.
Thank you, Mr. Jacobs. Mr. Sura.
Yeah, this is Matt Sura representing the town of Frederick.
Great. Mr. Lewis Prescott.
Stephen Lewis Prescott on behalf of the city of Tacona. Thank you.
Excuse me. Okay. Hey, lawyers, thank you for being here. This should be fairly quick. I have reviewed the record in the KPK Financial Assurance Plan docket that is scheduled for hearing next week. The primary purpose for calling you here today is to ask each of you if there's anything procedurally that we should take up now so that we don't like show up next week and then have a procedural matter that delays this hearing of the merits of this. I don't want to get on the merits today. I did note that there were a couple of motions. KPK filed a motion for discovery and one for a continuance. I also noted that recently staff's recommendation has kind of altered to maybe limit a little bit what the substance of the hearing is going to be about, but did want to just have a quick procedural hearing this morning. I'll start with you, Mr. Jacobs. At this point, do you and or your client have any matters that you want to raise procedurally ahead of next week's substance hearing?
Thank you, Mr. Chairman. Happy to jump in first. Procedural matters would include prior rulings of the hearing officer on our motions, both of which were denied. I would just state for the record that we do think discovery was appropriate. We drafted discovery, we sought discovery, we briefed the basis for discovery. We were denied discovery and sought information exchange informally with staff and were pretty much denied on that. That led to our supplementation on July 21st of the prior financial assurance plan, the Form 3 that was filed November 1st of last year. That substantial supplementation has resulted in the review by the director and the changed recommendation of staff, Exhibit 5 to the staff's pre-hearing filings, but Mr. Boudreau can certainly address that. I would also simply note that the e-filing system identifies my client as an enforcement respondent. This is not an enforcement proceeding, it's a financial assurance hearing, and I just want to clarify for the record that we're the respondent operator, not an enforcement respondent in this matter. There may be some other procedural issues that parties wish to address, but the fact that discovery was denied, we think was inappropriate. It was simply deemed not compelling. I don't believe that that's the proper standard either under commission rules or the rules of civil procedure. And I do think that discovery would have aided in our supplementation of the prior financial assurance plan submitted last November. We have other procedural concerns regarding the amount of time necessary for the hearing based on the scope of staff's planned testimony, as well as the relevant local government parties, City of Tacona and Town of Frederick, but we can certainly have that brief discussion here shortly.
So, Mr. Jacobs, understanding that things have sort of gotten to the place that we're at now,
Right.
With a new staff recommendation, which is actually somewhat consistent with your ask, knowing that there's still, you know, the one issue outstanding on salvage value and what that may be. Are you continuing today in a request for discovery, or has that sort of mooted itself out?
I think it is mooted by the change in position of the staff. I do, again, feel as though discovery would have been appropriate, but that issue is mooted. I agree with you, Mr. Chairman, on that point.
Okay, and then if we self-correct the record that this is not an enforcement matter, but this is a financial assurance matter, which I would agree with. We've taken care of that issue. Let's set aside in our back pocket the issue on time until I've heard from the other parties. If that's okay with you, Mr. Jacobs, have I addressed the three elements that you brought up this morning?
I'm sorry, Mr. Chairman, could you repeat that? I was distracted.
I just was saying, okay, so we've dealt with discovery, and that's no longer necessitated, let's say, if that's a legal word. I have corrected formally that this is not an enforcement matter. This is a financial assurance plan, and get that. And then thirdly, you have a question about time allocations. I want to sort of side check that until I hear from the other parties, and then we can all talk about that together. Have I successfully addressed the issues procedurally that you wanted to raise this morning?
There is one other issue. It concerns the prior Rule 211 claims, or maybe current, of the cities of Dacono and town of Frederick. And I wonder if that will be formally withdrawn verbally today, how that is procedurally addressed by the commission prior to the hearing next week. So I just have a question in that regard, and it's probably a question for Mr. Sura and Mr. Lewis Prescott.
Okay, that's noted, and appreciate that. Mr. Boudreau, I see that you're unmuted. Did you want to go next, or do you want me to call upon the city lawyers?
Totally up to you, Mr. Chair. I can mute myself. I think I just forgot to mute myself.
Okay, then let's move to the cities. Mr. Sura or Mr. Lewis Prescott, I don't know who wants to go first, but a similar sort of question. We're just trying to procedurally frame this so that we're in a good shape for next week. Where do your clients stand at this point?
Happy to jump in first. Thank you, Mr. Chairman. On behalf of the city of Dacono, Dacono is agreeable to bifurcating and later pursuing, if necessary, the 211 claims. That said, under the financial assurance rules and statement of basis and purpose, we believe it's clear that plugging is an option in the financial assurance discussions, as an alternative or a credit to single well financial assurance for option 4. So we are going to pursue a presentation that involves a request for plugging wells in the city of Dacono. And timing wise, we don't think we'll need more than an hour to put on our presentation. That has not changed. So I think that covers the two discussions or points coming over to the city. One being timing, don't see any issue with it. Two being 211, yes, Dacono will formally bifurcate that and revisit. So whether it's a dismissal without prejudice or some other procedural mechanism, the 211 bounds will not be discussed or pursued at this, but the request to plug wells based on evidence presented will be pursued. Okay, let me recognize AAG Davenport, who hopefully has been listening in to this stimulating discussion. AAG Davenport, can you give me some guidance on what sort of action I should take as chair on the 211 claims? And for everybody that's listening in, for the good of the cause, can you kind of help us understand what the 211 claims are and how it appears they've now been withdrawn? So AAG Davenport.
Thank you, Chair. And I'll note that obviously the 211 claims are requests of a party, and what I believe I just heard is at least from the perspective of Dacono, they do not intend to maintain a claim for plugging pursuant to 211, which for the commissioner's perspective is the used or useful in broad strokes rule. However, my understanding is that at least Dacono will still, in the context of financial assurance requests, and make a case for the commission to order some plugging, or perhaps just putting wells on the plugging list. I'm not entirely sure, but that's what I just heard. And the last thing I want to do is put words in everybody's mouth. So still a request maybe for plugging, but it's not in the context of 211 anymore. Now it's in the context of a financial assurance application.
Mr. Lewis Prescott, did my AG summarize your thoughts appropriately?
I believe Mr. Davenport did a good job of summarizing it. Yes.
Okay. All right. So that is, those thoughts are now in order of the commission in terms of how we're going to proceed procedurally with regard to Dacono's claims. Mr. Sura, on behalf of the town of Frederick, did you want to bring any perspective to this procedurally?
Yes, I do. Thank you so much. Matt Sura, representing the town of Frederick. Frederick has 107 KP Kaufman wells within its 15 square miles, and Frederick joined as a party to initially support the staff's request of $130,000 per well of financial assurance, and also to move that 95 wells that are inactive and low producing should be plugged and abandoned pursuant to 211. And then first, the staff requested that the town of Frederick remove its 211 claims or withdraw those claims. And we were certainly considering that. And the staff, I think, based that on the fact that it would confuse the issues to be talking about financial assurance and also the 211 claim. We do, like Dacono, intend to pursue that plugging and abandonment through the financial assurance plan, and also would like to be assured, and we're intending to bring this up with the hearings officer today, but could bring it up with you now, that when those 211 claims are put forward, that we could have a hearing within the next 3 months of those being put forward. Then just last week, the staff announced that it was, instead of requiring $100,000 for reclamation costs, they were going to accept KP Kaufman's contention that reclamation could occur for $7,834 per well. And we believe that was done without adequate background or staff analysis, and have then completely changed what we were intending to pursue through this hearing, and are now feeling like we're put in the position to defend the $100,000 requirement in the rules and the rules generally. Therefore, we're going to be asking for quite a bit of additional time. We also have supplemented the record just this morning with an analysis looking at as many wells as we could get to in the very short time that we've had within Frederick, and justifying the fact that they are indeed going to cost at least $100,000 per well location to reclaim. So to summarize, we're looking for having that additional information accepted and put into the record that was just submitted this morning. We also believe that it's in the interest of the commission, the state, this proceeding, to have expert staff on at the commission available for questioning around reclamation costs. We're presenting information from the staff as to what they believed was the reclamation cost during the financial assurance rulemaking, and would like to have them verify that. We're going to need 2 hours for testimony because we're now both adverse to KP Kaufman and the state, unfortunately. And again, we'd like to have confirmation that once we put forward a application, that we will have a hearing on that application within 3 months.
Okay. There was a lot there, Mr. Sura. Thank you. We will defer to the hearing officer on the 211 hearings that may happen down the road. So there's that issue, and that's how we're going to rule on that. You've asked for more time, and you've asked to supplement the record with something you filed this morning. It appears to me that the record is supplemented if you filed it, so that's in. In terms of more time, do you want more time between now and hearing? What's that ask?
It was asking for 2 hours for testimony.
Okay, so just 2 hours for testimony. Okay, I'm going to defer to you. You all have a hearing with the hearing officer here in just a bit, and thank you for showing up with me. I'm going to defer to the hearing officer to sort out the time asks, because also Mr. Jacobs has asked for more time as well, and we'll let the hearing officer sort of sort that out. That's what they're good at. And then if folks are still begruntled when you show up next week at the hearing and you want more time, we'll take that up procedurally before the commission. So I think I've just taken care of your asks, Mr. Sura, in terms of hearing time and in terms of information into the record. At this point, I would like to hear from AAG Boudreau.
Thank you, Mr. Chair. I believe you and the parties have summed up the issue, the remaining issues pretty accurately. As between staff and KPK, the remaining narrowed issue revolves around salvage value. And staff does not oppose Dacono and Frederick withdrawing their 211 claims or refiling them later. We agree that timing can be handled by the hearing officer shortly after this. And we understand Mr. Sura and Frederick's position, and that they are going to be presenting evidence on costs for reclamation. So yeah, I think everybody summed it up pretty well.
Okay, and having heard from all the lawyers here, I've not heard from anyone that there is anything that we need to address today that would delay hearing the merits of this next Wednesday. If anybody disagrees with that, raise your hand. And Mr. Jacobs, I see your hand is raised, but I think you raised your hand before I asked the question, but I'll go ahead and recognize you.
Thank you, Mr. Chairman. I do have some concern about the submission of additional information this morning by the town of Frederick. I've not reviewed that information. I can pursue, some resolution with the hearing officer here shortly in our final pre-hearing conference. With respect again to the prior discovery issue, I think that was mooted with respect to our discovery aimed at the staff. That was primarily to understand the criteria for evaluating demonstrated costs. That is mooted by the acceptance of demonstrated costs, or the recommended acceptance of demonstrated costs prepared in KPK supplementation. But I do believe that some discovery or information exchange with the relevant local government parties in light of their plans for the hearing next week would be in order, and would like to pursue that bilaterally with counsel for them between now and the hearing, and we can discuss that also with the hearing officer here shortly.
Okay, that's I appreciate that, and we'll let you take that matter up with the hearing officer. And just for the folks that are listening in the room to the things we're doing, we have kind of a process in which our adjudicatory matters are brought for hearing officer, who helps procedurally move these things along. I brought the attorneys in here today just to sort of check in, because ultimately whatever the hearing officer recommends is indeed a recommendation, and ultimately it's the decision of this body that procedurally sets out how we're going to hear an adjudicatory matter. Mr. Jacobs, you still have your hand up.
Yes, apologies. One last thought. It concerns the apparent intent of the relevant local government parties to seek a plugging and abandonment order in whole or in part for KPK wells in their jurisdictions as part of this financial assurance hearing next week. There is no standard for that articulated. They're relying on language in the statement of basis and purpose at page 65. And that alone, in preparing for the hearing, it would be helpful to address the issue of what is the standard for such an order. It also feels, to KPK anyway, a little bit like two bites at the apple. Let's try to get a plugging order here in financial assurance. Let's do it again in Rule 211. So I do think that there are some equity and fairness considerations there that potentially affect the scope of the hearing next week. Just want to bring that to your attention and the hearing officers.
Okay. That's more of a merits issue, so we'll let the hearing officer address that this morning in the final pre-hearing conference. Mr. Sura, did you have something? I see your hand is raised.
Yeah, I did. Thank you so much, Chair. The one other issue that I did raise was the need that I believe this commission has, and certainly all parties would benefit from having some experts from the staff available for questioning, including any reclamation staff, Dr. Denise Arthur, Curtis Conklin, Eric Nickel, anyone from the Orphan Well program. Again, we were told that none of the staff would be available because they're all too busy working on plugging and abandoning orphan wells to participate in financial assurance hearing, which I find a little ironic, but again, we are going to be relying on information that has been submitted and was in the financial assurance rulemaking record submitted by the staff, and it would be helpful, I think, for the commissioner and the public and all parties to have those staff members available.
Okay, and again, I'm going to defer that initial determination to the hearing officer. So raise that with the hearing officer at 9:30 or whenever you guys have your hearing officer determination. So thank you for that. And we will, if you're unsatisfied with kind of where things land, we'll figure that out next week. So thank you. Mr. Lewis Prescott, you had raised your hand, but I now see the hand is no longer raised. Are you good at this point?
I am. Thank you, Chair. You did resolve it in your comments.
Okay. All right. Procedurally, I think we've bumbled through this in a fair fashion. So thank you to all the lawyers. I'll let you all go attend a hearing officer final pre-hearing conference, and we look forward to seeing everyone next Wednesday for the financial assurance plan, non-enforcement plan information that we will receive then.
Thank you.
Mr. Jacobs, you raised your hand again.
Might I simply ask that we get a few minutes before starting the final pre-hearing conference, say 10 or 10:15, so we're all on the same page as to when to log into that?
Sure, I'm not going to be involved, but I will order the hearing officer to hold that at 10:15. And I also go ahead.
Thank you.
Okay. Commissioners, some of our staff need a bit of a break before we move to the next matter. So let's take 10 minutes and let's return at 10 o'clock for the next docket matter. Back, it is 10 a.m. and we will continue with the Colorado Energy and Carbon Management Commission docket. The next matter up is docket 220700182. This is an enforcement matter. It involves the operator 1876 Resources, formerly known as Cub Creek Resources. If we could elevate the attorneys to the fore for this. All right. In no particular order, let me recognize the folks that have visualized themselves. Mr. Dan, if you could inform us as to who you are and who you're representing.
Good morning, Commissioners. Randy Dan, Davis, Graham, and Stubbs, representing 1876 Resources, formerly known as Cub Creek Energy.
Great. Mr. Foote.
Thank you, Chair. Good morning, Commissioners. Michael Foote representing Kathy Kemper in this case, and she is also present.
Okay, great. Mr. Kirshner?
Thank you, Mr. Chair, Commissioners. Steve Kirshner, ECMC Enforcement Supervisor.
Great. Okay. Last week we took up this matter procedurally, and at that time, each party was afforded 5 minutes for oral argument, exclusive of commissioner questions. We have a second final pre-hearing order setting the order of the argument. I believe that has Mr. Foote going first on behalf of Ms. Kemper, then staff, then Cub Creek 1876 Resources. If anyone desires to reserve time for rebuttal, please let me know. Commissioners, I think it would be helpful to hear from everyone before we jump into our questions. However, if you want to have questions after an oral argument, you can certainly do that. I will attempt to keep track of the 5-minute time. And I believe that actually, I think I maybe misspoke, but that Kemper, Mr. Foote, if you want to reserve rebuttal time, you've got that opportunity. I don't believe we have rebuttal from the other parties. So if I misstated anything, attorneys, raise your hand. Otherwise, we will recognize Mr. Foote.
Commissioner,
Right.
I apologize to interrupt. My colleague Kate Sanford should also be on the Zoom. Can she be elevated on the panel as well?
Hearings Manager Amaro, if we could elevate the individual that Mr. Dan desires to be elevated, that would be helpful.
Mr. Chair, she's not in the attendees yet, unless she has, I see a Kathy, but I don't know if that is her.
Mr. Dan, do you know how she identifies herself in the Zoom meeting?
They're in a conference room in our Denver office. I don't know if it's showing up it should be showing up as 1876 Resources. She's on right now. I apologize. I don't know if she can raise her hand, if that will work.
Okay, I see a 1876 Resources. We're going to elevate them.
Thank you.
All right, we've got a conference room of folks that are identified as 1876 Resources. If you could mute yourself at this time, we're going to hear from Mr. Foote first. All right, Mr. Foote, you are recognized.
Great. Thank you again, Mr. Chair, and good morning again, Commissioners. I plan to highlight a couple of things during my 5 minutes that I hope you'll pay close attention to when making your decision on this exception. The first is making sure the standard of review is defined correctly. Second, I'll talk about the staff's clearly erroneous reliance on inapplicable precedent. And finally, I'll talk about moderate versus significant adverse impact. But before all of that, I wanted to remind you of the profound effects suffered by Ms. Kemper during these noise violations. This wasn't just a few days, wasn't just noise exceedances that occurred out in the middle of nowhere. This was months of excessive noise about 500 feet from her home. Imagine an alarm clock going off at unpredictable times during the day and night, sometimes for hours, sometimes for a few minutes, but you have no ability to turn it off and don't know when it will come back on. Eventually it turns off on its own, but it may come back on in an hour, or it may come back on 3 days later. And it continues that way for months. To anyone going through that would cause a significant adverse impact to them. And that's the same for Ms. Kemper with these noise violations. So getting into the standard of review, first, as we indicated in our filing, the clearly erroneous standard does include a, quote, definite and firm conviction that a mistake was made, but it does not include a plausibility element. The staff filings in this matter have continuously tried to expand the petitioner's already high burden by putting in extra requirements like a plausibility standard that have no support in the law. It is whether there's a definite and firm conviction that a mistake was made, period. Secondly, you are conducting a de novo review of this matter. We are not disputing the factual findings in the hearing officer's order. We are disputing the analysis used by the director in the first place. Therefore, the hearing officer's legal rationale is not applicable in your decision-making, and the staff's reliance upon it in its response to the exception is misplaced. We acknowledge we have the burden to show the director's decision was clearly erroneous, but we don't have the additional burden to show the hearing officer's legal rationale was also clearly erroneous. Second, regarding the lack of prior precedent. In short, there is no applicable precedent to what happened to Ms. Kemper. The 2015 extraction noise violation is just not applicable to this case, and to rely upon it was clearly erroneous. To say the 2015 extraction violation is applicable precedent in this case is like saying apples and oranges are the same thing because they're both types of fruit. Just because one case involved a noise violation doesn't mean the other noise violations must follow the first. But the staff treats the 2015 violation as similar and binding to the current case, even though it is clearly much, much different. Just to quickly compare the two, with the extraction 2015 violation, there were 11 noise complaints over 3 days. With the current night pad violations, there were 38 noise complaints over the course of a year, an AOC period that lasted for 68 days, preceded by 5 months of excessive noise complaints. So 8 months total of excessive noise complaints and 5 failed noise tests over that time period. Common human experience tells us 72 hours of excessive noise and interrupted sleep is just orders of magnitude different than the same thing over the course of 8 months. An unpredictable alarm clock is bad enough for a 3-day period, but not being able to escape it for 8 months is a whole different story. The impacts are just totally different. And let's not forget, the commission, and among other things, its mission, have completely changed since the 2015 violation. But the current AOC transports us back to the pre-181 days, when the commission's new focus on health and safety should give us a much different decision today. In fact, even though the staff response to the exception argues it would be arbitrary to not follow the 2015 extraction case, we believe it's quite the opposite. It will be arbitrary if you do follow the 2015 extraction case. There is simply no support for using the 2015 extraction case as binding precedent in this case. So finally, given the lack of precedent for this violation, what should have happened? To get there, you just apply the plain English meaning of moderate versus significant. You know what those terms mean, but our exceptions cited the dictionary definition of the terms. The extensive impacts suffered by Ms. Kemper were simply not moderate. They were plainly and obviously significant, and the commission should make such a finding. So in summary, we'll ask the commission to reverse the director's decision, finding just a quote moderate adverse impact in favor of the accurate significant adverse impact, and send this AOC back to the staff for that adjustment. So thank you, and I'd like to reserve any of my remaining time for rebuttal.
Let me unmute myself. That was 5 minutes and 4 seconds, so there is no rebuttal time, but thank you for that presentation. At this time, I believe staff is recognized.
Thank you, Mr. Chair. Good morning, commissioners. Once again, my name is Steve Kirshner, ECMC Enforcement Supervisor. As you know, the directors before you today asking that you deny the exception and you uphold the recommended order. So I want to first briefly touch on the standard of review. So Rule 520C, which governs exception proceedings, states that the commission will conduct this review on the same record before the hearing officer and a de novo review of the law. Now, the Colorado APA further elaborates here, stating that findings of evidentiary fact made by the hearing officer shall not be set aside by the agency on review unless those findings are contrary to the weight of the evidence. So this proceeding is a new look at the law and the legal questions, but it must be done within the framework of the hearing officer's findings of fact, including those listed in the AOC and explicitly incorporated and adopted into the recommended order. That the review is de novo, it does not require you to ignore the recommended order. That order goes into great detail on each argument now before you, and it serves as a valuable roadmap and a resource for your evaluation. So with that in mind, I want to briefly look at some of the issues explored in the director's response to the exception. In order for you to grant the exception, you must find that the assessment of a moderate impact factor was clearly erroneous. Now, this is a high bar. As the hearing officer noted, the review must be significantly deferential to the director. Case law requires a definite and firm conviction that a mistake has been committed. The hearing officer also stated that it's appropriate for the commission to defer to the director regarding the terms of an AOC unless there is either no support in the record for that decision or the record so overwhelmingly contradicts the decision that the commission is convinced the director made a mistake. You heard a lot about the precedent here, and I'd like to talk about that a little bit. Staff looked to order number 1V572 here as precedent in informing this impact factor decision. Now, this prior order involved multiple complaints, strikingly similar to those in this case. The details of those complaints are listed in our pleading, and that led to a violation of noise-related conditions of approval. The commission ultimately approved a moderate impact for that violation. Now, the exception alleges that the prior order is somehow inapplicable due to the difference in the number of complaints and the duration. Now, the hearing officer already considered and rejected both of these arguments. As the hearing officer stated, the similarities in the content of the complaints, when considered with the evidence in the record here, support the director's reliance on the prior order. Regarding duration, the director argued, and the hearing officer agreed, that duration is already accounted for as a specific variable in penalty calculations, and the $60,000 difference in total penalty between the prior order and the current AOC appropriately accounts for that difference in duration. The hearing officer ultimately found that nothing in the instant case here compels a finding of clear error based on the reliance on that prior order as precedent. Regarding the impacts alleged in the complaints and reiterated in the exception, the hearing officer found that those allegations did not perfectly align with the evidence obtained by staff through its inspections and its sound studies. The hearing officer went on to state that in the absence of clear evidence of the long-term impacts alleged in the petition and the exception, and in light of the director's responsibility to prove up all alleged violations, the severity of the alleged impacts did not rise to such a level to demonstrate that the assessment of a moderate impact was clear error. I want to stay on that responsibility to prove up alleged violations and the deference afforded to the director in these matters. In determining impact factors, Commission enforcement guidance states that the gradation applied to impact determination lies wholly within the discretion of the Commission and the director. The director and staff have significant institutional knowledge and experience, not only in determining impact factors, but also in negotiating settlement agreements, including corrective actions, and ultimately determining whether the available evidence is sufficient to prove those allegations should a matter end up before you in a contested hearing. As the hearing officer stated, in a case where a moderate or major finding could be justified, deference to the director's broad discretion is required. The record does not leave one with a definite or firm conviction to disturb that discretion. Commissioners, it is the protestant's burden to show that the director's decision was clearly erroneous. As we've described in detail in our responsive pleading, this is an extremely high bar, and I submit to you that the exception does not meet that bar. As the hearing officer stated, while the record could potentially support a major degree of impact, such a close case clearly indicates that the clear error standard is not met. The recommended order is detailed and thorough, and it should be affirmed. For the reasons laid out in the director's response, the director therefore asks that you deny the exception. Thank you.
Thank you, Mr. Kirshner. At this time, I believe we will hear from either Mr. Dan or someone sitting within the room at Davis Graham and Stubbs.
Good morning, commissioners. Go ahead, Andy. All right. Good morning, commissioners. My name is Kate Sanford. I'm an attorney at Davis Graham and Stubbs, and I'm here with my co-counsel, Randy Dan, on behalf of 1876 Resources. Also in attendance is Ryan Sokolowski, who is the regulatory manager at 1876 Resources, Trenton Rico, who is the vice president of operations, and Tim Sulzer, who is the chief executive officer. First, we would like to emphasize that 1876 Resources, formerly known as Cub Creek Energy, has and continues to take this matter very seriously. Each time it received notification that it was exceeding the noise thresholds, it made significant changes to its operations to reduce the noise as quickly as possible. Within a matter of several weeks, after installing 42 sound panels and making various other changes, the night pad was well within the applicable limits. As a preliminary matter, we would like to emphasize that we do not have any intent to minimize Ms. Kemper's descriptions and experiences of living near the night pad. However, we strongly encourage this commission to make a decision that is based on concrete data rather than subjective experiences. As emphasized in our exception brief, the data in this matter clearly speaks for itself. It shows that the noise thresholds were exceeded in only 3 instances, and in each of those instances, the noise was only barely exceeding the limits in Rule 423. It does not practically make sense that 3 minor exceedances of noise violations can amount to a major violation. This would be a significant outlier from how every other violation has been classified. At this point, we don't think it's necessary to walk you through the facts and legal matters at issue because an extremely extensive record has already been developed. However, we would like to take the time to emphasize that the record establishes again and again that the complainant has presented no compelling reasons for reclassifying the violations as having a major impact rather than a moderate impact. Most importantly, as evidenced in the record, hearing officer Thomas Elias has already carefully considered every aspect of this case, including each alleged impact to the complainant, the relevant legal standard, and each sound study. The matter was fully briefed before the hearing officer, and a half-day hearing was conducted, complete with extensive oral argument from each party. Hearing officer Elias then issued an extensive recommended order that thoroughly and carefully considered whether director's decision to classify the violations as having a moderate impact was clearly erroneous. The hearing officer concluded that, quote, the impacts described, while actual, did not amount to a major degree of impact on health, safety, and welfare of persons in light of past assessments of harm or direct human impacts. Ms. Kemper is now raising the exact same factual and legal arguments with this commission. Yet she presents no compelling reasoning for why the hearing officer's extensive order was inaccurate. Instead, she once again provides lengthy descriptions of her frustration with having an oil and gas well sited near her house. But subjective descriptions of experiences, no matter how extensive, are insufficient to provide a basis for categorizing 3 minor noise exceedances as a major violation. There must also be concrete and objective evidence. And here, as shown in the record, there is no concrete or objective evidence that establishes that 3 minor noise exceedances should amount to having a major impact. The last point I'd like to make is that Ms. Kemper is seeking an extraordinary remedy by asking the commission to, first, reverse the director's thorough and researched decision, and second, reject the hearing officer's carefully articulated recommended order. It is well settled that an agency has broad discretion to choose how to classify a violation based on the evidence before it. In light of this broad discretion, and when the record is viewed as a whole, it is clear that the director's decision to classify the violation as moderate should not be disturbed. Thank you.
Okay. We've now heard from oral argument on the issue from all 3 attorneys. At this time, I will turn it to commissioners for any questions of any of the attorneys before we move into deliberation. All right, the lawyers must have done a good job because I'm seeing no questions. So we now will excuse the lawyers and move toward deliberations amongst the commissioners on the issue at hand. Does anyone desire to start with deliberations? Commissioner Cross.
Thank you, Mr. Chair. Let me actually get in front of my camera here. I just want to start off. I think to me, what really sticks out in this case is the standard of review. And when you look at the clearly erroneous standard, that is an incredibly hard standard to overcome. I do not in any way, shape, or form want to make light of Ms. Kemper's situation. I think that I can't even imagine what would be going through my head if I was dealing with excessive noise levels over that period of time. However, I think in brief, I think that the idea that the review and the determination made was clearly erroneous is just simply not the case. I think when you look at not just the 2015 example, but also look at what is considered a major impact, I think the differences between a consistent disturbance, a consistent annoyance, a consistent, I think nuisance is probably the appropriate term here, but I think that consistent problem compared with explosions, that consistent problem compared with being sent to the hospital is definitively different than what Ms. Kemper was experiencing here. Again, I don't wish to make light of what happened to her. I believe that this is why we have these strong rules in Colorado to make sure that things like this don't happen. And it's bothersome to me that it happened at all. But I don't think in any way, shape, or form this could be considered clearly erroneous in the decision that was made to go with moderate as opposed to a major impact.
Thanks for leading off, Commissioner Cross. I'm somewhat in agreement with the analysis that you have articulated and appreciate you setting that out for our consideration. Other commissioners with deliberative thoughts? Commissioner Messner?
Thank you, Mr. Chair. I'll apologize in advance because my thoughts are going to be a little bit all over the place. But I've reviewed all the information in this docket. I've listened to the arguments that were just presented by the attorneys associated with this, reviewed the hearing officers' review of this particular case. And I would agree that the standard of review is pretty clear, which is clearly erroneous. I think that there's no question that there is a violation here. I think that there's no question that there was a impact that was associated with this. It is also clear to me that there's significant discretion and deference given to the director in a determination of the degree associated with this impact. I also think that there is a clear guidance document that's developed around enforcement policies and procedures that has been utilized in determining how enforcement staff manages NOAVs, how they manage AOCs and negotiated settlements. I think that there was a pretty significant burden of proof associated from the complainant to determine a clearly erroneous standard or a clearly erroneous review. I do believe the complainant focused the primary portion of their argument towards the degree that was determined here. And I think as we look at the classification or look at the enforcement guidance, there's two axes associated with determining classifications. One is the actual classification, 1, 2, 3, and then there's the degrees, minor, moderate, major. And as I review this as a whole, I'm struggling to find evidence that shows that there was a clearly erroneous application of the enforcement policies and procedures that are utilized by the director and the enforcement staff in these type of proceedings. That's not to negate the fact that there was a violation. That's not to negate the fact that there was impact associated with that. And so that's where I initially stand on this. Now, outside of these arguments, as I reviewed this case, it's clear to this commissioner that there are elements of our enforcement policies and procedures that are outdated. They have not been updated since 2015. There's been significant changes in the mission of the ECMC during that time, including the implementation of Senate Bill 19-181 that changed the mission of the agency to regulate oil and gas in a manner that protects public health, safety, welfare, the environment, and wildlife resources. There was significant deliberation and evidence provided during the mission change rulemaking around noise, in developing the noise standards, and in developing in determining what are the public health and welfare implications of noise. As I look at our current enforcement policies and procedures, it appears to me that we are, that some of the things in there don't correlate with our new mission and the rules that have been developed as part of SB 19-181, including classification of certain rules. As I reviewed it, there's even rule numbers in there that don't correlate with current rules in our rules. And so, for example, there is classifications in there for water quality as a classification of a 3, general environmental protection classified as a 3, air quality classified as a 3, waste disposal classified as a 3. You know, at the time in 2015, there was weeds and trash classified as a 2, odors and dust classified as a 2, lighting classified as a 2, visual impact classified as a 2, and noise abatement classified as a 2. As I reviewed the statement of basis and purpose associated with Rule 423 and the development of that rule, there was a lot of discussion about the fact that noise really was a public health, safety, and welfare issue, and is directly related to SB 19-181 and the mission change rulemaking. And so that made me think that perhaps our rules aren't appropriately classifying the potential impacts of noise as not a nuisance, but as a public health and welfare consideration. So having said that, in my opinion, and particularly based on recent case law that determines that making modifications to an enforcement policy or procedures guidance in application of a particular docket is inappropriate, I do find that the enforcement staff have applied and the director have applied the enforcement guidance and policies appropriately in this particular case, and I don't find that there is clearly erroneous, anything clearly erroneous associated with this. However, it's this commissioner's opinion, not within this docket or not within this case, that ECMC staff should be directed at the conclusion of this to review our enforcement guidance, policies, and procedures to update it to better reflect the mission change rulemaking and the change in mission associated with SB 19-181. Those are my thoughts right now. I'm sorry they were a little all over the place.
No, I appreciate the deliberative thoughts, Commissioner Messner, and appreciate that. You know, we're looking at this matter based upon what's on the books currently, but the fact that this matter may have educated ourselves and our staff that there needs to be a revisit to the enforcement policy, that's a positive and productive thing, and we can appreciate Ms. Kemper's bringing this to our attention, and there may be some additional guidance from commissioners on that point outside of a specific hearing today. Commissioner McGowan, did you have deliberative thoughts?
Thank you, Mr. Chair. And I agree with everything that my fellow commissioners have already stated. I will add to Commissioner Messner's thoughts about updating our guidance. I think we also decided or deliberated during 181 that because of the incredible detailed discussion about noise and what level it should be at and whether it's a nuisance and whether and to what extent it can go beyond just being a nuisance, we decided that we should, I think, review noise standards. And I think it was a suggestion by Adams County to follow a standard that they had created, if my memory serves correct. And I don't think we finished that because Commissioner Gonzalez was working on that before he left, and I don't think had a chance to finish it. So I'm in agreement. Anyone who has experienced something for themselves, it's impossible for someone else to say how that was experienced. And I think noise is one of those very explicit examples where I can't state if that was just a nuisance for Ms. Kemper or if that was something that was more significant, and she's stating that it is. But the rules that we have now and the guidance that we have now, I think were applied appropriately, and I don't see that how they were applied is a clear error of our standards or how they were used. And I'm going to echo my fellow commissioners. It's not meant in any way to diminish the experience that Ms. Kemper had. Sorry, my dogs are rustling here in the background. But I agree with my fellow commissioners and what's been said thus far.
You're muted,
Hey,
Mr. Chair.
Davenport, if you could visualize yourself. Seeing that we appear to have consensus, what form of motion am I looking for?
Thank you, Chair. If it's the commission's pleasure, and it sounds like it is to determine that, or it's the commission's decision that the director's decision was not clearly erroneous, then my suggestion is a motion to deny the petition. And if also it's the commission's pleasure, you can adopt the hearing officer's recommended order as your own order to be supplemented by your deliberations here today. And what will follow this matter is a written order from the commission, which, as I said, can both adopt the hearing officer's recommended order as an order of the commission, but then add additional findings and conclusions based on the deliberations here today. So to sum, deny the petition from the complainant, Ms. Kemper, and then if it's the commission's pleasure, adopt the hearing officer's recommended order to be supplemented by your own.
So moved.
Second.
Motion and a second. Is there further discussion? Seeing no further discussion, all those in favor of the motion signify by saying aye. Aye.
Aye.
Mr. Chair.
Commissioner McGowan.
Thank you. So I do think at minimum, to Commissioner Mesner's point, our guidance needs to be updated to reflect our updated rules at minimum. And perhaps somewhere down the line, we need to have a discussion about maybe reviewing the guidance and at minimum looking at the noise piece, because I think that's something we committed to in our Senate Bill 181 deliberations.
Yes, and so I think the motion carried. Did not see any no votes. And I
Sorry, it was
believe
unclear to me what was being encompassed then by what AAG Davenport was saying there. So I thought I just wanted to talk maybe a little bit about what that meant. I maybe should have asked that before we all voted, but
yeah, no problem. AAG Davenport, I believe that the motion that you articulated that I then moved and that was seconded was as to the specifics of this application. And we also have now informed ourselves that we want to have further discussion about the enforcement guidance with staff and perhaps with direction to clarify, modify, bring it up to speed and in conformance with 181, et cetera.
Yes, so procedurally, what I'd say is my motion was limited to how to resolve this matter being docket numbers 220700182, not including direction to staff to do something in regard to the enforcement of penalty policy. So what I'd suggest is we clarify for the record that the motion that I suggested, which Mr. Chair, you then so moved and was seconded by Commissioner Cross, passes unanimously. And does not include direction to staff in regard to the penalty policy. And perhaps once we clarify that that motion has passed unanimously, then the commission can make some specific direction to staff in regard to the penalty policy or something else. I would prefer not to confuse the record about the motion at this point. So if we could just clarify that that motion passed unanimously, and then perhaps have that discussion about what direction to provide to staff. That's my recommendation.
Okay, so I am articulating that, in my opinion, the motion passed unanimously. If anyone has a disagreement with that, please pipe up now. Seeing no pipe up, that motion passed unanimously. And now, Commissioner Messner, since you raised the issue, would you like to articulate at least your initial thoughts in terms of direction to staff? I mean, you've already done a pretty good job, but give you another shot. And then Commissioner McGowan, certainly want to recognize you as well on that front.
Yeah, thank you, Mr. Chair. I would like to see this commission provide direction to staff to update the enforcement policies and procedures and associated guidance documents that were last updated in 2015 to clearly reflect the work that's been done since 2015 and the evolution of the mission of ECMC now twice to first regulate oil and gas in a manner that protects public health, safety, welfare, the environment, wildlife resources, and then if appropriate, to also update it associated with the change in our scope from solely regulating oil and gas development to the expanded scope that the last legislative session has provided to us, and then provide that to us for deliberation and consideration.
Great.
So I don't know if we need to make a motion or not. And so
yeah, I don't know that we need a motion. I think we can just provide this direction. Are the other commissioners in agreement with this direction as provided by Commissioner Messner? Okay, I'm seeing nodding of heads in the up and down fashion, so that's a positive. So staff, you were so directed, and we look forward to having a dialogue with you about these issues. And as you are working on this, you can dial in Commissioner Messner, who's got his fingers on this, for further direction, etc. AG Davenport, is that good?
That's good from my perspective, Chair. I think what's contemplated is staff will make revisions, and then it's as per the direction from the commission, and then at some point we'll bring those back to the commission for further consideration, modification to the enforcement and penalty policy.
Okay. Excellent. All right. So we have now taken advantage of and dealt with docket 2207-00182. We have one last docket number before us today. That's docket 2302-00041. If we can elevate the relevant attorneys for this docket, we will then take it up. And I believe that Deputy Director Larson is in the Wasatch room with at least one of the lawyers for presentation purposes. So let's give him a second. Okay, it appears that we're having some technical issues. Let's take about a 5-minute break and return at 10:50.
Hello.
Folks could start to show back up. We're waiting to get started.
Mr. Chair, this is Deputy Director Larson. We are here in Wasatch, and you'll have on the camera, we'll say my name, Mimi Larson, but this is Mr. Kimmel and his client. So if you are ready to proceed with this docket, we are ready to go.
Okay, we're waiting on Commissioner McGowan to be able to come back to the docket. So let's give us a second.
Of course.
Why don't we go ahead and do introductions as we're waiting? So Deputy Director Larson, if you could have the attorney in the room introduce himself and his client.
Yes, good morning, commissioners. This is Thomas Kimmel of the law firm of Zarlingo and Kimmel. At this hearing, I represent the surface owner, Edward Dumpf, who's present beside me today.
Okay, thank you very much. Mr. Campbell.
Good morning, Mr. Chair, commissioners and staff. My name is Scott Campbell. With me today is Rob Willis, Polson, Odell and Peterson LLC. And on behalf of the petitioner, Renegade Oil and Gas Company LLC, we have Ed Ingby, who's the president and owner of Renegade, and JB Conville, who is the vice president of land and CFO.
Okay. Is there anyone else I need to recognize before we proceed to the docket? Seeing none. So attorneys, I've taken a look at the docket, and this is an application for plugging and abandoning and closure of the, and I don't know how to say this, Necken well, number 1, and Strauder well and oil and gas facilities. However, at least this commissioner believes there is a procedural issue that we need to address before we take up the merits of the matter, and that is whether the arbitration provision in the settlement agreement between petitioner Dumpf and Renegade precludes Dumpf from bringing its application to the commission. I would like to allow the attorneys for both sides to procedurally provide a few minutes of oral argument on that point, and then we will address that point before we get to the merits of the matter. Mr. Kimmel.
Yes, thank you. Thank you, Mr. Commissioner. The rule as to arbitration is well settled in Colorado. And what it says is that in order to have an arbitration an arbitration clause be in effect, it's necessary right from the start for the applicant or the petitioner to make a motion to compel arbitration. And when a litigant takes actions that are inconsistent with the authority of the arbitrator, then they waive their right to arbitration. So the main problem with what Renegade has done here is they filed their petition, essentially their answer to the application. In this case, I think it was in April or May, and made no mention of an arbitration clause. That would have been the time for them to have moved to compel arbitration. But instead, they filed a petition on the merits with no mention of wanting to have arbitration. And under the Colorado Supreme Court case of Condolera, and I'll be happy to give the site, I don't have it right here, but I'll provide it to you. The Colorado Supreme Court has held that if a litigant takes actions that are inconsistent with an arbitration clause, they waive their right to arbitration. The second reason why this motion is not valid is that this is not a dispute under the 2013 settlement agreement, which contains the arbitration clause. We are not claiming any breach of that agreement or a private contract between the parties. There's no provision in that agreement talking about closing a well or plugging and abandoning a well. It's not a dispute that has arisen under that settlement agreement. So for those two reasons, the arbitration clause does not apply and has been entirely waived by Renegade.
Mr. Campbell.
Thank you, Mr. Turn that down.
Mr. Campbell, you are resonating in it's like you have
better,
two,
Mr. Chair?
Yeah, that's much better. Thanks.
Turn it up a little bit. I can't. Let me handle it. Thank you, Mr. Chair. First and foremost, I'd be interested in seeing this alleged authority that Mr. Kimmel has asserted is dispositive here. It's been my understanding that the issue of arbitration is a jurisdictional question, and that can be raised at any time, at any point in the proceedings. But in point of fact, paragraph 12 of our petition specifically states that the act defers to private contracts and further acknowledges that these issues can be subject to arbitration agreements. The settlement and release agreement contains a binding arbitration clause. We've made those arguments in a motion for summary judgment that we filed. Unfortunately, we didn't, when we asked for leave to file the motion for summary judgment, which was attached as an exhibit to the motion for leave, we failed to state that we were contemplating it would be an issue that would be resolved by the commissioners, because of course the commission has an original jurisdiction, if you will, as opposed to the hearing officer over a Rule 211 application. And Mr. Thomas assumed or thought that we were asking him to resolve the issue. So he denied leave to file our motion for summary judgment without prejudice and explicitly acknowledged that we could reassert those issues in the proceedings before the commission. We in fact made the arbitration point in our pre-hearing statement, and we made it again in our responsive pre-hearing statement. And instead of responding to those arguments, Mr. Dump's responsive pre-hearing statement is comprised of about one paragraph with 3 sentences that says they're not obligated to respond to the factual or legal issues that have been asserted by us in any of the filings. So we do believe that the issue is ripe before the commission. Parties can waive rights to proceed before legal entities, including agencies. And they can waive their rights to exercise certain substantive claims or make certain substantive claims in courts and federal courts. They certainly can do so before this commission. And then finally, I'm a bit confused about the assertion that Dump is not pursuing any issues that are covered by the contracts. I could walk you through the provisions of the contracts that control on whether or not this well has utility. And in point of fact, when you look at their pre-hearing statement, their response to the pre-hearing statement, and most notably their proposed order, they are asking you to make findings of fact and conclusions that Renegade has breached the terms of these contracts. And they've done that in blatant disregard of controlling Colorado Supreme Court authority and without acknowledgement of that authority and without any attempt to even distinguish the current factual circumstances under that authority. So we do believe the issue is open, ready to be resolved by you, and this matter should be dismissed. Thank you.
Okay. Commissioners, I as one commissioner believe that the meaning and effect of the arbitration provision is somewhat outside the scope of our ability to resolve. I am not sure that I'm convinced that it was not appropriately raised. And I think at this point, at least from this commissioner's perspective, we're not really at a spot in which to take up the merits of this, because I believe the meaning and scope of the arbitration provision needs to be resolved between these parties. And that's not for us to resolve. That's for either a court to resolve or them going to arbitration and doing that they're supposed to do, or they reach an agreement that the arbitration provision is not effective. But I'm not in a spot, at least from my position, to be able to take up the merits, because I think that is a seminal jurisdictional issue that needs to be resolved between the parties and not by us. As a lawyer, and I am still a lawyer, I would suggest that we dismiss this action without prejudice, which means it can be rebrought once the arbitration provision is dealt with in the appropriate forum. The other alternative that I can think of, and I'm just winging it here, is that we just sort of stay it and allow it to just remain on the docket. And then once they're able to come back to us via agreement or via an arbitration or via a court making a determination on arbitration, then we would take it up. I think I'm kind of in favor of the dismissal without prejudice, so that it's not just sort of languishing on our docket. Those are my thoughts as chair on this. Happy to hear from my fellow commissioners on this point as well, and appreciate Commissioner Cross raising his hand.
Thank you, Mr. Chair. I'm in full agreement with you, and I'm also in favor of the dismissal without prejudice. Our commission doesn't have the authority to interpret the arbitration clause and the validity of the arbitration clause. That's beyond the scope of our jurisdiction, in my opinion. And so I appreciate you bringing this up, because it's absolutely what I wanted to raise this morning as well. I think this is properly brought either before an arbitrator or before the court, more likely before the court. But with respect to your two options, I believe that staying it is not appropriate. In my opinion, I think the dismissal without prejudice is the appropriate take on this. As you said, it can be refiled and brought at that time, but I don't think it's appropriate at this time for us to be determining the validity of an arbitration clause when that's not what our jurisdiction mandates as a commission.
Great. Thank you, Commissioner Cross. Other commissioners with deliberative thoughts on this procedural question and or AAG Davenport, if you have any guidance as well, that's appreciated.
Mr. Chair, I don't have additional guidance unless there is a request from a commissioner for additional guidance. But
Okay.
I don't have any additional points to provide at this point.
All right. I'll just take the lead, and I would move that we dismiss this petition without prejudice, which means that it can be re-brought at such time that the arbitration procedural matter is clarified by someone that's got jurisdiction over that, or by agreement of the parties. And that's a motion.
Second.
Okay, we have a motion and a second. Is there further deliberation on the motion? Seeing none, all those in favor of the motion signify by saying aye.
Aye.
Any opposed? Motion carries. Thank you to the parties. We look forward to you resolving these procedural matters, and if it needs to come back before us, we've got an appropriate forum and venue for the issues that are jurisdictionally appropriate to us. All right. I believe that takes care of the docket of the Colorado Energy and Carbon Management Commission. Is there anything further from anybody? Seeing none, I would look for a motion to adjourn.
So moved.
Second.
Motion and a second. All those in favor signify by saying aye. Aye.
Aye.
All right. Thank you, folks. We will see you, if not before, next Wednesday.